In this case, strikes at the very core of our principles as Americans. I think that the case is very important because I think that the First Amendment is very important, and our freedom to speak out against wrongdoing in government is one of the hallmarks of our Republican democracy.
This case is about fundamental First Amendment rights in the workplace, involving a plaintiff who was terminated from a government position for doing the right thing.
In this case, our client, Colleen Bradley, was an employee of a public entity, Westchester University, and spoke out against what she believed to be corruption and wrongdoing in connection with the budget process, whereby individuals at the university and at the state system generally were advancing this scheme that Colleen believed to be fraudulent. This case involves potentially 30 million federal and state and municipal public employees who encounter all kinds of things in the course of their jobs. And this case impacts what they're able to say in this country with the First Amendment right of free speech without being subject to retaliation by the government.
Colleen Bradley's case is very, very significant in the sense that our U.S. Supreme Court has established precedents on speech within the workplace and whether or not that's protected. That case is Garcetti versus Ceballos. And the court, since Garcetti in 2006, has really only addressed the First Amendment in the workplace issue in a case called Lane versus Franks, which is a case in which the court establishes and mandates that speech by government employees like Colleen Bradley should be protected. Those employees, because of their positions, are the only ones to know that government corruption is happening, government impropriety is happening. And that case talks about encouraging and protecting that speech. And where we are in this Colleen Bradley case is that there's a very dangerous Third Circuit precedent thus far in the case, which seems to ignore that mandate. And there is it appears, some dissension within the circuit courts around the United States on how Garcetti is to be applied, particularly when you get to speech that actually happens within the workplace. At this juncture in the Bradley case, Bradley took the least disruptive path to try to expose government corruption and has thus far been shut down by the courts.
The Third Circuit ruled that Colleen's speech was not constitutionally protected because the Third Circuit determined that when she was speaking out against the wrongdoing, the corruption, the fraudulent practices that she believed to be existed, she was doing so as an employee and not as a citizen. In this case, the Third Circuit made a factual determination that Colleen was speaking as an employee and not as a private citizen, despite the fact that we had record evidence right out of the mouth of the defendant, her supervisor, that when Colleen was opposing what she believed to be the corruption, she was not doing so in the ordinary scope of her employment. Just let me read you some excerpts from Mr. Mixner's testimony, deposition testimony, that Dan and I, coming out of his deposition, believed constituted extremely strong evidence that Colleen was not acting as an employee, but was not acting in the ordinary course of her duties. Mr. Mixner was asked, was it part of Ms. Bradley's ordinary duties to investigate misrepresentations of financial information, yes or no? He answered no. Question, was it part of Ms. Bradley's ordinary duties to report willful misrepresentations of financial information? Answer, it was not part of her job description. Question, yes or no? Answer, no. Question, was it part of Ms. Bradley's duties to report to senior leaders of Westchester University outside of her chain of command what she in good faith believed to be unethical practices? Answer, no. Question, was it part of Ms. Bradley's ordinary duties to report to senior leaders of Westchester University outside of her chain of command what she in good faith believed to be unlawful practices? Answer, no. Question, was it part of her ordinary duties to report to senior leaders of Westchester University outside of her chain of command deliberate falsification of budget projections to maintain taxpayer funding? Answer, no. Question, was it within Ms. Bradley's ordinary duties to submit her version of the budget to the EMC committee, that's the Enrollment Management Committee meeting? Answer, it was not within her normal duties. So that litany of admissions by Mr. Mixner that when Colleen attended the EMC meeting, the Enrollment Management Committee meeting, and expressed her views that what was going on with the budget process constituted fraudulent misrepresentations, it seems very clear from Mr. Mixner's testimony that she was not doing so as an employee, because none of those things were in the ordinary scope of her employment. And yet the Third Circuit made a determination that she was speaking as an employee, and that's one of the glaring errors that we believe was committed by the Third Circuit, particularly in the context of summary judgment. A jury should have determined, based on that testimony, whether Colleen was acting as an employee or a private citizen, again, based on that record testimony. The court took it away from the jury and made its own determination based on its own subjective views.
The case is not a case involving a he said, she said situation in terms of what happened here factually. And one must realize that the falsifications of the budget that are at issue in this case actually occurred over the course of a 3-year period, where there is numerous correspondence, emails of Miss Bradley trying to rectify these misrepresentations. There's even minutes coming out of committee meetings where Miss Bradley raises the issue, and there's no internal disagreement that there were misrepresentations going on here. In fact, throughout the litigation, the defendants have not contested our allegation that the speech in question, which was exposing these misrepresentations, involved a matter of significant public concern. That's one of the elements that you need to prove a First Amendment violation and to have First Amendment rights. And in this case, there is no defense to those allegations, because the truth is that year after year, the budget would be completed, and then Ms. Bradley would be instructed by her superiors to make one entry that would turn a significant multi-million-dollar gain into either a loss or a break-even budget, on the basis of which Westchester University, PASHE, all the other profitable schools within the 14-member state system would either inflate or maintain the state appropriations. This case, Bradley, represents an opportunity to put a better framework around how courts in this country are supposed to apply the Garcetti test to determine whether the employee was actually speaking within the course and scope of their ordinary duties.
So you all now are asking the Supreme Court to take up this case. What do you see as the implications or the consequences if the Third Circuit decision is allowed to stand?
I think that the Third Circuit decision in the Bradley case bodes very ominously for First Amendment jurisprudence and the effect that it will have on public sector employees. As I mentioned, the Third Circuit is very highly regarded with good reason. Our judges are the cream of the crop. So other circuit courts of appeal are going to look to the Bradley decision as very persuasive authority in this area. And where if the Third Circuit's ability to impose its own view of what the facts should be as opposed to what the actual facts of record are, then that's very dangerous, because it gives courts anywhere where they're interested in following the Third Circuit's lead on this, the ability to do so, to become a super jury in determining before the facts are even presented to a jury what the ultimate factual outcome should be, irrespective of what the factual record of the case is. To me, it seems they're obvious. Of course, I'm not a government employee, but this decision affects me because I sure as heck want the government employee who was aware of wrongdoing in government to speak out about it and let people know. I think it was the great Justice Louis Brandeis once said that sunlight is the best disinfectant. Well, people who work in government are in the best position to shed light on wrongdoing that's occurring in government. And as a non-government citizen of this country, I certainly want those people in the best position to know what's going on, to speak out against it. Otherwise, we're all going to get ripped off until it's too late. So this case has very broad implications, not only for the 30 million people who work in the public sector that to which we referred, but to everyone, to all of us who count on public servants to act with our best interest. And when they see something going on that's not in our best interest, to shed light on it and call it out without having to be subject to retaliation, as the Bradley case involved.
So for my sake of my kids and my children's kids and everybody else, it is about doing the right thing. And if I didn't do the right thing, how do I ever live with myself?